Hello to everybody and welcome. And I'd like to thank you for joining us today and spending part of your Earth Day with us, focusing on environmental justice. My name is Giovanna DiCiro, and I'm professor of environmental studies and coordinator of the program on environmental justice and climate resilience here at Swarthmore College. Along with my two wonderful co-organizers of this webinar, Ms. Zulene Mayfield and Dr. Chris Mele, who will introduce themselves in just a moment, I'm delighted to welcome you to this 1.5-day webinar titled Looking Back, Moving Forward, Law, Policy, and Environmental Justice. So to start off today's events, I'd like to invite Oswaldo Morales Solorzano, who is Swarthmore College's Sustainability and Engaged Scholarship Fellow, to offer a land acknowledgement. Oswaldo?
Thank you, Giovanna. This webinar, though virtual, is being hosted in Lenape-Hoking, the ancestral home of the Lenape, which stretches across lands now called New York, Pennsylvania, Delaware, and New Jersey, among others. We acknowledge and honor their enduring relationship to this land and commit to serving as responsible stewards of it, guided by knowledge and culture. As we embark upon this journey thinking about environmental justice, which is intrinsically linked to land and to place, we invite you to think about the land that you are on, wherever you may be, and join us to build a more inclusive and equitable learning space for present and future generations.
Thank you very much, Oswaldo, for that beautiful land acknowledgement. I would also like to acknowledge and extend our gratitude to our co-sponsors who have generously supported this webinar: the Lang Center for Civic and Social Responsibility, the Environmental Studies Program, and the Office of Sustainability at Swarthmore College, and the Baldy Center for Law and Social Policy, and the Digital Scholarship Studio and Network at University at Buffalo. We are also deeply grateful to the college staff and the students who helped to design and construct our website and who have helped to make this webinar run smoothly. So I want to give you just a very brief overview of the plan for the next 2 days. In this morning's first panel, Looking Back, Learning from Title VI, our panelists will take a deep dive into thinking about and critically assessing the goals and the outcomes of the landmark 1996 environmental justice lawsuit, Circle versus Seif. Then after a lunch break, we will reconvene at 2 p.m. Eastern Time for the second panel, What's Happening Today, Reshaping Environmental Justice Law and Social Policy. On this panel, our speakers will describe current environmental justice efforts that they are organizing in Chester and elsewhere, with a focus on how they are using new dimensions of law and policy to advance their organization's goals and the goals of the environmental justice movement more broadly. And finally, for the third panel, which will start tomorrow, Saturday, April 23rd at 10 a.m. Eastern Time, our panelists will help us to think about moving forward. And they'll be sharing with us some of their thoughts on what they see as the next steps and future visions for advancing environmental justice and for building a just transition locally and beyond. You can find more details about each of these three panels and the bios of our panelists and additional resources about the topics that we'll be discussing. You can find this on the conference website that's linked in the chat. So I hope that you will join us over the next 2 days for all three of these exciting panels. So I'd like to turn the floor over to Ms. Zulene Mayfield, Chairperson of Chester Residents Concerned for Quality Living and co-organizer of this webinar, to welcome you and say hello. Zulene?
Good morning, everybody. I see a lot of friends in the as attendees. I'm glad that you all are here. Oh, that just scared me. You gotta let me know what you're doing this, Bob. This Bob. With this technology. But welcome to everybody. I'm Zulene Mayfield, Chair of Chester Residents Concerned for Quality Living. Our organization has been in existence since 1992. I hope that we learn a lot and forge new roads as we move forward in seeking environmental justice for communities like Chester and Chester, PA. Back to you, dear.
So, Nuseba, you can share that screen so that Zulene can just invite people to the march on Saturday.
And tomorrow, we celebrate Environmental Justice Day. We are having our second annual march. It will begin at Chester City Hall at 1 East 4th Street in Chester, PA. We march down to the Covanta incinerator. We will have speakers. We're inviting everybody to come. If you are part of a larger organization, please bring your banners, your signs. We have a lot of signs already made, but if you have signs unique to your organization, please join us. We will assemble at 12:30 and the march will start at 1. And that is tomorrow, April the 23rd. Hope to see you there.
Great, thank you, Zulene. So now I'd like to send it over to Dr. Chris Mele.
Hi, everyone. My name is Chris Mele, and I'm a professor of sociology at the University of Buffalo. This year, I am an NEH Mellon Fellow for digital publication, which means I'm basically working on a project or a number of projects and initiatives in Chester City to facilitate folks sharing their ideas, their knowledge, locally constructed in digital ways, and this conference being one of them. So I would like to, again, welcome everyone today, and I look forward to a great conversation. We're going to begin panel 1 soon, but at first I want to turn it over to Nuseba to ask her to talk a little bit about the logistics of the panel for attendees as well as the panelists.
Thank you, Chris. And my name is Nuseba. I'm the Civic and Environmental Engagement Fellow with Swarthmore, and I'm excited to hear both from our panelists, but also from our audience. So if you have any questions throughout the panel, please feel free to drop them down in the Q&A tab down at the bottom. And hopefully at the end, when we have time, we'll answer your questions. Otherwise, if we're unable to answer your question during the conference itself, we'll be populating some of those questions onto the forum, which we'll add into the chat in a little bit so that you can see the answer to those questions. We're also recording this conference so that you can view it later afterwards, as well as to share it with friends who couldn't join us in live time. But thank you, Chris. I'll pass it back to you.
Great. Okay, so without further delay, I would like to start with panel 1, looking back. And first, I'd like to just briefly go through the panelists and who their affiliations. And then I will talk a little bit about Circle versus Seif. And then we will move to the panel and having discussions about the case itself, and more importantly, the situation surrounding it. So our panelists today are Ms. Zulene Mayfield, the chairperson from Circle, who we've met a few seconds ago, Mr. Lewis Morse, a Chester resident and board member of Circle, Mr. Michael Churchill, an attorney at the Public Interest Law Center in Philadelphia, Professor Gilbert Carrasco, professor of law at Willamette University Law School, Mr. Mike Ewall, director of the Energy Justice Network, and Dr. Sheila Foster, professor of law at Georgetown University Law School. Now, this case, Circle versus Seif, just a bit of kind of facts and details and background. From November 5, 1996, was submitted to the Eastern District of Pennsylvania District Court. For context, Mr. Seif was at the time the secretary of the Pennsylvania Department of Environmental Protection. Now, the case involves Circle suing PADEP for issuing a permit to Soil Remediation Service Systems, SRS, a company that was planning to build a facility to clean petroleum contaminated soil by burning off the contaminants. The soil burner facility would have been, and this is significant, sandwiched between existing waste facilities, including the trash and sewage sludge incinerators. In the case, the plaintiffs argued that the existing permitting process for individual facilities did not factor in the clustering of these other polluting facilities and the increased dangers that each of these and collectively and cumulatively brought to community health. The issue of permitting of permits, as it was at the time, created a waste cluster that has clear and obvious effect of subjecting particularly African Americans, who comprise 70+% of the adjacent residential population, to racial discrimination. The defendant's refusal to modify the waste permit program made the defendants, according to the case, liable for violation of Title VI. The suit, again brought to the Eastern District Court, was brought under sections both 601 and 602 of the Title VI of the Civil Rights Act of 1964. Very briefly, 601 provided that no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in or be denied the benefits of or be subjected to discrimination under any program or activity receiving federal financial assistance. 602 authorized and directs agencies such as the EPA, which provides financial assistance to agencies like PADEP, to effectuate the provisions of 601 by issuing rules, regulations, and orders of general applicability, which shall be consistent with achievement of the objectives of the statute. 602 is referring, and we'll see a little bit later, to the disparate impact that discrimination claim is making. The district court, in its ruling, did away with the first cause of action, citing Supreme Court precedent that ruled that 601 applies only to intentional discrimination, and that Circle failed to allege that PADEP intentionally discriminated when granting the permit to SRS. Circle appealed the ruling to the Third Circuit Court of Appeals, focusing only on the second cause of action, the core 602 claim of discriminatory effects or disparate impact of discrimination against a federally funded permitting agency. The Third Circuit reversed the district court's ruling and found that there is a private right of action under 602. PADEP appealed that to the US Supreme Court, but by the time the case reached the highest court, PADEP had revoked the permit for SRS, and that was the end of the permit challenge formed the basis of the case and was therefore rendered moot. Now, as I said, I don't want to spend time on drilling down into the details of this, so I want to share my screen very quickly. And for those who are attending, we have, of course, our conference webpage, and our students at Swarthmore in particular have spent an inordinate amount of time and wonderful workflow here of putting up a lot of relevant information, not only for this panel, but for panels 2 and 3. But referring to this panel, we have several sources related to the case background, and just the case itself, and the impacts of the case. So I encourage you to check out this page for the purposes of familiarizing yourself with more of a detailed look at this case than I just provided. So let's move quickly here. Why this case? So within the context of the study of environmental law, Circle versus Seif is considered an important, significant case. It appears on most law school syllabi for environmental law courses. It's been the focus of multiple law review journal articles. It's referenced frequently in studies of books and articles on environmental racism and environmental justice. But our purpose this morning is not to drill down on the case itself, because that has been written about, again, quite a bit, but the story of the case from the perspective and the viewpoints of the principal actors, many of whom are assembled here today. The idea of today's objective is that law and legal avenues are best understood by knowing the details of the context, the situation that led to the use of law as a strategy in the struggle for environmental justice. For the panelists assembled today, hindsight is most welcome. We have before us this unique opportunity of bringing together individuals intimately familiar with the case, but more importantly, the thinking, the mindset, the political circumstances, and the environmental movement itself at the time in which this case is situated. So as this first part of this conference states, looking back, what we are asking each of you to do is to share your stories, your recollections of the movement at the time, the obstacles and opportunities it was facing, and the insight on the decision to pursue the suit. What happened after the suit and how that shaped movement strategies moving forward. In short, what was learned. So at this point, I'd like to turn it over to our first two panelists, and I ask the two of you to kind of decide maybe a conversation and dialogue as opposed to formal presentation, so to speak, for Louis and Zulene.
Good morning, everyone. First, let me just thank everyone who was responsible for this event. Nuseba and Chris, thank you for your communications, keeping me informed on what was going on, and Giovanna for summarizing everything for me for today. Thank you so much. Zulene and I go back a very long time, and as I looked back on the moment in time where we came together as a community to do something that was unheard of, really. As we were doing it, I didn't think of anything like that at the time. It was something that we knew needed to happen. But again, as I was looking back, I had to look at the city of Chester and the community. The community has always been pelted with lemons. And we've always survived the lemons that were pelted, that were pelting us. There's never been an issue that this community has not rose above. The crime, the poverty, the dysfunctional school system, the businesses that left, no jobs, unemployment, corrupt government, boarded houses, homelessness. We've survived all of these pelting of lemons in our community. But surviving lemons relies on the ability to turn lemons into lemonade. And we were able to do that with the ones that I forementioned here. We were able to educate our children with a dysfunctional school system. We were able to keep kids off the street, away from crime. We didn't catch all of them, but we were able to do that. We were able to put people into housing who were homeless. But this one lemon, this huge lemon that came into our existence without our knowing, this incinerator was forced on a community and no one said anything to us about it. So when we got that lemon, Zulene came to me with the energy that she has. And I'll tell you something, the energy that I felt that day from her when she said, Louis, and she said it just like that, Louis, I need you. And I said, you need me for what? And then she explained to me what had been happening. And immediately, the energy transferred to me. And I want to tell you, looking back on that, as I thought about this over the night, as I'm as I'm up all night, I thought about the things we did. We took our bodies and we put ourselves in harm's way, stopping trucks and people.
From trying to kill us.
Yes.
From trying to kill us.
From
We
trying to
realize
kill us.
the killing.
But anyway, we took ourselves and we put ourselves in harm's way because we knew that the Goliath we were fighting was bigger than us, but we knew that we were a David. And it was our turn to throw some lemons.
Mm.
We rallied every week,
Good.
shutting down streets.
Every week, okay?
With our bodies, we shut down streets. We stood in front of trucks. We stood in the middle of the street. We stopped them. But Title VI was our lemon. Title VI was our lemon. We were able to sling that at this huge industry. And we wanted to see if they could make lemonade. And what we realized was that, and this is how I saw it, Title VI was our answer to a corrupt government. Title VI was our answer to a government that turned a deaf ear to the community. Title VI was our platform to fight. Title VI gave us the energy, the enhanced energy to move more and faster and bring more people into existence to fight this fight. We're here today because of the energy that still exists around that nucleus of people who stood in the battle to fight. So as I look back and I see the transformation of our community, we're still fighting all of those issues that we've been fighting in the past. But this one was bigger than them all. And we knew we had to do something different. We knew we had to stand a little taller. And we knew we had to give a little more. We had to sacrifice.
Yeah.
So Title VI, when Jerome met with us, he said, you've got a shot to take them down. And I don't know if you remember, Zulene, but the night we met in our office to make a decision to shut them down or to do something different, it was an all-night event for us. We were on the edge of shutting this company down. If we had walked out of that office that night with that decision in our heads that we were going to do that, that would have happened the next day. But here it goes. We had things that we never really thought about. We had people from the incinerator coming to our office fighting us because we were shutting them down.
They sent the whole workforce.
The whole workforce came to our office door and threatened to kill us if we shut this place down. And our board met and I don't know if you can feel this right now, but we had a decision to make that was going to transform the lives of many people on both sides. And so we had to be very critical about what we were going to do. And we had to make a decision that was going to be the right decision, not for just us, for everyone. So we decided not to shut down, but to work with. And we decided that because we knew that people needed to work. So Title VI just really, it elevated us because it gave us more fighting, it gave us more ammunition to fight and more ammunition to fight even more because we were now able to fight other battles, not just the incinerator, but other battles that were coming at us left and right. So we did everything, and moving forward, we knew that we had to work together. We had to strengthen our board. We had to strengthen our people that were with us. We had to keep them motivated and keep them actually moving forward with us. And Zulene was a very good leader. She helped people understand, and she's able to do that. Understand that the importance of what we were doing, transferring that to them so that they could feel the mission, that they could get a hold of the crusade. I get a little emotional about it because my mother was out there. My mother's 84 years old now, and she's still on the battlefield. She's still fighting. And she always asks me, what's happening now? And I can't really give her a full dissertation as to what's happening now because I'm not fully involved right now because of work situations and so forth. But I see it. I'm always hit. My ears are always there. My eyes are always there. And I'm fighting battles elsewhere. I'm in communication with Zulene, so I know what's happening. We have a lot to do. Title VI gave us our platform, and we worked it, and we were able to be successful with it. And I think I think we needed it. I know that now. I know we needed it. Without it, I don't know what we would have done or how we would have done it. But that's really what I see right now. You know, we did a lot. We did a whole lot. And some people aren't with us anymore that were fighting.
Yes.
Some people have passed on, but we still have people who are strong, who are still following, who are still fighting. And we thank all of you for coming in when you did, whenever you did, to continue this effort. Because it's not over, it's getting stronger and stronger. It's getting stronger and stronger. And I feel something coming on horizon. We have something going on right now that's going to make some changes in the city of Chester. This community is going to change.
Absolutely.
It's going to change. With that, I say thank you. I hope I've given you something to nourish your soul and think about. I don't know what else.
Well, you got me crying this morning, early in the damn morning. So, anywho, thank you, Louis, so much. Like he said, we've been friends a long time, and I thank God for the longevity of friendships. I think if you get to the end of the term, you still got friends in life. All the stuff we go through,
Yeah.
Friends, that you lived a good life.
Yeah.
When we were approached by Jerry Balter from PhilCop at the time. I knew a little bit about Title VI, but a lot of members in the community had no idea what it was, what it meant, and why we should do it. A lot of times on these type of battles, people think as soon as you get an attorney, that's the magic solution. Everything will be right. Everything will go away.
Yeah.
And you can transfer all of your burdens to that attorney. But I realized that it was nothing but another spoke in the wheel that we needed. It was another tool. It was another avenue to engage and to try to level the playing field, because there was no playing field for us. The ditch had already been built for us. We had been thrown in that ditch. And at the time when the suit was initiated, I think we had 4 permits that we were actually battling against. 4 at one time. Yeah. 4. Yeah. With no technical assistance. Really just a basic knowledge of the technology or no knowledge of the technology. And very little assistance. But we had a desire to learn. And with some of the senior folks where they didn't understand the technology, it was our role to break it down into a level where they could understand it. Yes. The same thing applied to this lawsuit, because people were like, well, why do we want to do that? And like I said, some people were like, well, why did you want to do that? Other community members were like, okay, great, this is the solution to all of our problems. But we knew that it was just an avenue. We knew that it was not the magic solution for everything, but it leveled the field with these entities that were making decisions that impacted our lives. Hold on for 1 second, please. I'm sorry, everybody. But that's what it did. And it, as Lewis said, it gave us a little more energy, a little more oomph. Another day to go on, another day to, okay, yes, this battle is worth it. Another day, that our seniors were like, okay, now I'm still hopeful. And that's what it meant to me. That's what it meant for them. I don't think that at the time we realized the history that we were making. We just assumed that everybody was doing this. And I didn't know it until I went to Atlanta and I was approached by a group of Black attorneys who basically got me in a corner and said, well, your attorney is nuts. He shouldn't do this. It's the wrong move. And I'm looking at all of these, educated Black attorneys. And I'm like, okay, well, where you guys been at? You knew about us. We had absolutely no knowledge of you all. And where y'all been at? So don't tell me that my attorney is crazy, because I'm crazy too. We're like the perfect match for each other. And we ride or die together. Whether it's right or wrong, we're going to move forward with this suit. Because they were trying to convince me to have him withdraw the lawsuit. And I'm like, I don't see the logic behind that. I'll listen to you. However, Jerry Balter is our dude. We trust him. I didn't always like him at times. Oh no, we would go at it. But I trusted him. I trusted that he knew the law. And he spoke it, he tried to break it down to us as best he could. We would take and interpret that for the other community members. And we went forward with it. We stepped out on boldness and on faith that what we were doing was the right thing. Even with the realization, even if it could not help us, that somewhere along the line, somebody else could be helped
Mhm.
by using the same avenue. So it was hard to engage some members of the community. And it just took a little bit longer time to do it. I'm sorry, but I had somebody had doing some work. I'm triple dipping today. However, that's what it meant to me and for us as a community. It was just another leveling tool. But I can tell you what did happen after we filed that suit. It got a little bit more quiet in Chester. The permits, people stopped applying for permits to come to the city of Chester. So you have to look at what is a win versus what other people view as being a win.
Mhm.
But it stopped it, and it stopped it cold.
Yes.
So that was a big win for us. So back to you, Chris.
Thanks, Zulene. Michael and Gil, if you would like to please jump in and give us some of your recollections.
Sure. First of all, I want to just say it's a pleasure to be able to participate in this conference because it's my way to honor Zulene and her colleagues and my beloved former colleague, Jerome Boulder. I was the back office person. Jerry was the person that was really has the stories, and I'm sorry that I don't. But what they accomplished in protecting the health of the Chester community for some of the most egregious racial targeting and noxious profiteering deserves really to be honored. Their success is uncommon, and it came from Zulene's tireless efforts and her energy, as Lewis described it, as an advocate, and Jerry's creative commitment to try whatever would help in her organizing efforts. It really is important to set the context, as Chris said. Chester was not really a pre-existing hazardous waste site like Love Canal. Instead, it was a site being carpet bombed by new polluting site permits because it was a 65% minority enclave in a county which was 91% white. In the 10 years prior to the Seif case, while 2 minor permits for about 1,400 tons of waste that have improved in the county outside of Chester, more than 2 million tons of waste processing had been approved in Chester. The Westinghouse incinerator processes all of the solid waste collected in the county and dumps it in Chester City, 840,000 tons a year. There's an Albanese recycling permit for 375,000 tons, and Delcora sewage treatment plant has a waste permit for 17,000 tons of sludge. An important piece of the context was that in 1993, Thermal Pure Systems had received a permit for 146,000 tons of infectious waste to be treated there. You have to realize that that amount was 4 times the amount of all of the infectious waste generated in the entire state of Pennsylvania. And the plant hoped to be a destination for infectious waste up and down the I-95 East Coast corridor. That was their plan. So the community, with Jerry's help, challenged that permit in state court. And it originally was successful. Commonwealth Court granted injunction, but that was rejected by the Pennsylvania Supreme Court in 1995, which held that the plant, which was going to sterilize the waste rather than dispose of it, didn't need any waste permit. And it was a signal that the state courts had little interest in protecting minority communities or maybe even any communities. Fortunately, Thermo did not proceed with that permit, and we'll discuss that in a minute. Also in May of 1995, EPA issued a draft environmental risk study for the city of Chester, which was intended as EPA's first cumulative risk study. And that was done because, again, of Jerry and Zulene's nudging of the EPA and DEP. It had found that 60% of the children had lead levels above recommended thresholds, and quote, cancer and non-cancer risks from the pollution sources in Chester exceed levels which US EPA believes acceptable. Nevertheless, there was no program about what they would do about it. Instead, that was when DEP gave soil remediation services a permit to incinerate the 900 tons per day of oil contaminated soil that Chris described. It did not appear to Jerry that the SRS permit violated the Clean Air Act emission limitations, which don't recognize the injury to the community from the noise, the vibrations, the stress, the constant truck traffic that all this permits puts in, nor the additional amounts that are concentrated. But Jerry said and discussed with the community, why couldn't a minority community be protected from the discrimination of being the only area not protected by DEP from the ravages of these pollution permits? And as described, the Civil Rights Act of 1964, which prohibits discrimination in schools and public facilities and employment, also covers federally assisted programs, and the DEP permitting program is such a federally assisted program. And as noted, that both covers intentional and disparate impact. And there was not really any way to prove DEP intentionally located environmental permits in the city of Chester, since they don't apply for where the locations are. But nevertheless, the question is, why doesn't that constitute a disparate impact that is covered by the regs? And so that's what the case complained about. It actually complained about both, and we eventually dropped the disparate treatment case. I'm going to let Gil talk about the case and what it did, but I want to go back to a couple of other points, because eventually, as was said, the case wasn't successful. All right, in the sense that it didn't have a legal conclusion upholding or denying the permit. It did set the way for future denials. The Third Circuit came back in a case also brought by the Law Center involving the Department of Education, and affirmed that there was a private cause of action. Then the Law Center teamed up with Camden Legal Services and Sheila Foster in 2001 to challenge an environmental permit for a cement grinding plant in Camden. Judge Orlasky found the prima facie case and of disparate impact and enjoined operation of the plant. A great victory for the very same place that what we were trying here in Chester. And 2 days later, Justice Scalia did what everybody feared. He issued an opinion in Sandoval declaring there was no private right of action by citizens to uphold the Title VI regulations. Nevertheless, as Zulene said, Chester was successful. The thermopure plant didn't go forward, and the SRS plant did not go forward. How come? Well, what hasn't been said, and you can never be sure, is that the other thing that Zulene and Jerry had done was get the city to pass a zoning ordinance which prohibited new trash facilities in the community unless replacing existing ones. And DEP said until you had a valid zoning permit, you couldn't get an air permit, or at least couldn't construct it. That ordinance had been written on behalf of the concerned residents and enacted by City Council because of the lobbying pressure that Zulene and the committee put on. It's a wonderful example of finding a way to regulate environmental uses of land without the complications of environmental risk assessments or who's causing the harm. And it would be, I think, I'd like to suggest a way that is politically possible in many communities because they are much smaller units of government than trying to deal with the state. But the problem with that, of course, is that it doesn't really focus on the on the racial injustice. The good part of the Title VI is that it really does require, it provides an organizing tool, because what it focuses people on is the racial injustice that lies behind the damage. Nevertheless, the basic problems that existed then still exist today, which is the unwillingness of state agencies charged with issuing permits for polluting activities to look at how to protect minority or poor communities from the unprepared, unfair proportion of those facilities being dumped in their communities. Environmental agencies see themselves as making chemical safety decisions, if you will, not decisions about fairness of location. EPA has the power to force state agencies like DEP to actually enforce these civil rights acts, and advocates have been trying to make that happen with not great success for at least the 20 years since Seif. Maybe the new EPA Equity Action Plan issued earlier this month is going to help start that process to become a reality. But alternatively, I think advocates need to develop other tools like zoning or health ordinance, which deal directly with regulating or eliminating polluting sources when there are health indicators that show that the populations are particularly vulnerable. Lawyers can help do that. They're harder in some ways to organize around because they don't focus on the harm to the community in terms of its racial and identities. But nevertheless, it is a way that advocates need to look at. But Title VI is still there. And part of the question is, how useful is it? And I'm going to let Gil talk about the problems we had using it and what it could do now.
Thank you, Michael, and thank you all. It's so good to see all of you from so many years ago, 25 years ago on this Earth Day. I just want to share a few reflections on my involvement in the case. And of course, at the time, I was a professor at Villanova Law School and also the vice chair of the board of directors of the Public Interest Law Center of Philadelphia, where Michael was chief counsel and Jerry was a lawyer, Jerry Balter. Of course, as a member of the board of directors, I was intimately familiar with the litigation in which the center was involved. And when this case came up, Jerry asked me about it, and I was a civil rights lawyer, not an environmental lawyer at all. And Michael and Jerry asked me to write a couple of memoranda of law on the civil rights dimensions of the case, and I did. And that case was filed in the district court, and the federal district court judge dismissed the case. We all, got together and we thought, well, this is not the end of this case. This case should be appealed. So I collaborated with Michael and Jerry on the appeal. I was very gratified when they asked me to argue the appeal in the Third Circuit. And I still remember sitting on the bench at counsel's table there just before the argument. And I was reviewing a variety of the opinions. There were 6 different opinions in the central case that really drove the jurisprudence of the law of the case at the time, the Guardians Commission case versus the city of New York. And I was counting heads just before I got up to argue the case. counted the heads that supported the idea that Section 1983 might be the basis for the case as a cause of action. And the central issue, the jurisprudential issue in the case, was whether we could rely on the regulations which provided an effects test rather than rely on the statute which required proof of intent to discriminate. And just before I got up to argue, Jerry leaned over to me and he said, "Gil, don't forget what this case is about, what this case is really about." And of course, it was about Zulene Mayfield and the Chester residents for concern for quality of living. That's what the case was really about. And that's the first thing I opened with in my oral argument before the three judges, Judges Cowan, Roth, and Lewis. And I emphasized, what was really at issue in the case at the outset, before I got into all the technicalities of private rights of action and Title VI regulations and 601 and 602 and all of that. Interestingly, right out of the gate, the first question Judge Roth, who is an African-American judge from, oh, he wasn't? Oh,
She is absolutely not.
Judge Lewis, I'm
Lewis
sorry.
is, yes.
Judge Lewis was an African-American judge from Pittsburgh. He asked me, well, I see that your claim is that Section 1983 could be the basis of a cause of action here. Can you tell me what justices on the court were of that view? And as I mentioned, I had just counted heads before I got up to argue the case. I was able to answer that question right out of the gate, which was really fortuitous, frankly. But the argument went very well. The chief judge, I think was Cohen, was the presiding judge. He commended both counsel, the counsel for the Department of Environmental Protection of Pennsylvania and me for our arguments. And we didn't know what would happen in that case. But I was confident that we were right. There were a lot of cases decided by the courts of appeals that had ruled that there is a private right of action of the regulations. And I remember in the elevator going down from the courtroom downstairs with Michael and Jerry, and I still remember one of the nicest compliments I've ever received as a lawyer. Michael turned to me and said, that was one of the best oral arguments I ever heard. And as a lawyer, it doesn't get any better than that, because Michael Churchill, in his own right, is a tremendous lawyer. So that was always very meaningful to me. But before that argument, I forgot to mention that I took this case very seriously, and I really thought that we had to win this case. And I had worked previously at the Civil Rights Division of the Justice Department in Washington, D.C., and had done civil rights cases all over the country. And I arranged for some lawyers to assemble, both from the Environmental Protection Agency and from the Civil Rights Division, and go through a moot court with me. Actually, they did 2 moot courts with me. So in preparation for the oral argument in the Third Circuit, I actually presented the case to these lawyers as a dry run, as a rehearsal, basically. And having worked at the department, these are really, there are a lot of really good lawyers there. So that prepared me to answer the questions from the bench when I got there, because they drilled me with a lot of questions that were difficult and probed the outer reaches of the argument. And, when we won that case in the Third Circuit. That was a huge win for environmental justice. I mean, it might have been the biggest win at the time for environmental justice. And it's still on the map as one of the biggest cases, one of the most significant cases in the environmental justice movement. And, you know, the celebration was short-lived, though, because the Department of Environmental Protection appealed to the US Supreme Court. And the court granted the petition for a writ of certiorari in the case. They agreed to hear the case, which is a very unusual step. The court only agrees to hear just a fraction of the cases that are petitioned for. And that was one of them. And, you know, we all thought, this is not a good sign for the Supreme Court to want to hear this case. As I recall, Michael, and correct me if I'm wrong, I think that we consulted lawyers around the country, both in the environmental field and in the civil rights field, to see how to go forward, to consult, because whenever you have a case in the Supreme Court, there's always a risk of making bad law. Even in the Court of Appeals, there's a risk of making bad law. And it's better never to have brought the case than to make bad law. And that's why it's so important to select your plaintiffs carefully and your facts carefully if you want to do a reform case, as I tell my students today. And so in any event, the SRS company decided to withdraw their permit, and shortly thereafter, DEP revoked the permit. And those were both really good events, because that was the focal point of the litigation. That particular permit was the focal point. And so we were able to submit something to the court, which they call a suggestion of mootness. And we told the court, you know what? You don't need to hear this case. This case is moot, because you have to have a live case or controversy for the court to have jurisdiction over a case. And so the court agreed with us, and we dodged a bullet. The court dismissed the case as moot, and so it didn't go forward in the Supreme Court. And we all suspected what happened just 4 years later in the Alexander versus Sandoval case. And that is exactly what Michael described earlier, that the court determined that there is no private right of action under the Title VI regulations. You have to show intent to discriminate under the statute, or forego litigation, because there is no way to go forward under the regulations. Except there is one exception that remains a vehicle for litigation under the Title VI regulations and the effects test. And that is the ability of the Environmental Protection Agency to assert a disparate impact based on environmental justice and other concerns involving Title VI of the Civil Rights Act of 1964. And as Michael mentioned, just this month, the Environmental Protection Agency released its Equity Action Plan under Executive Order 13985. And as it happens, and in that action plan, they specifically reference the effects test under the Title VI regulations. So they themselves recognize that they still have the power to assert rights, notwithstanding any lack of intent to discriminate, proof of intent to discriminate. Now, as it happens, a colleague of mine has become the point person for environmental justice at the EPA, working very closely with Michael Regan, the secretary of the EPA. And so she's an environmental justice person. That's her expertise. And so I just want to put out there that to the extent that there is an issue in Chester or elsewhere with which I can help, I am happy to facilitate a communication with my friend at the EPA and facilitate a contact.
I'm ready, Gil.
Yes, yes,
I'm
absolutely,
ready.
Zulene.
I'm ready. This building bridges, create collaboration.
You got to
We're
construct
ready.
those bridges. And so I'm just about out of time here, but I just want to mention that another part of the action plan is a commitment to reach out to communities with environmental justice concerns, as they put it. And so they have really come to the conclusion that there needs to be input from community activists like the Chester Residents for Concern for Quality Living. And so, you know, at this point, I just want to end with one quotation, a brief one, from something that Robert Bullard wrote years ago. And I also want to acknowledge Sheila Foster's great work and her seminal article called Intent and Incoherence that was published shortly after our case was decided. But Robert Bullard says, and I quote, "Change in the dominant environmental protection paradigm did not come from an effort made by regulatory agencies, the polluting industry, academia, or the industry built around risk management. Instead, impetus for the change came from a movement led by a loose alliance of grassroots and national environmental and civil rights leaders who questioned the foundation of the current environmental protection paradigm." And that is so true. And I think the case in Circle versus Seif is such a good example of that, you know, combination of grassroots organization and lawyers who know something about environmental law and civil rights and putting it all together for a great victory. And, you know, I hope that we can continue to have, you know, the strength to move forward, notwithstanding any of our, you know, shortcomings or setbacks like the Supreme Court decision in Alexander, because where there's a will, there's a way. And it is possible to fight City Hall.
That's
Let's move forward.
great. Thank you so much, Gil and Michael. That's it's very important context and providing a lot of great dimensions that we did not know about, at least I should say I didn't know about, which is fantastic. Thank you so much. We have about 25 minutes officially left for this panel, and we have two remaining panelists, Mike Ewall and Sheila Foster. So just to keep that timing in mind. So I'll turn it over to Mike for some comments.
Thank you. So this is going to sound a little cynical, but I promise it gets positive at the end. So I want to kind of run through some of the legal history of this and then look a little forward more for where some of this is going. So like was described already, the Chester case is very novel in using the Civil Rights Act to sue for environmental racism. And like other decisions before it, it reestablished that you don't need to prove intentional discrimination. You just have to prove that there's a discriminatory effect. And when the Supreme Court decided it was moot, they overturned that precedent. They set it aside and said, basically, you have to start over. That happened soon after in Camden, in a very similar community, but different industry. With some of the same attorneys were involved. And again, that court was agreeing and saying, yes, you don't have to prove that discrimination is intentional. You have a private right of action, is what they called it, to sue, even if you're just saying the effect is discriminatory. In the course of that Camden case playing out is when that Supreme Court decision on a totally different issue, I think it was an English-only driver's license case out of Alabama, called Alexander versus Sandoval, that came down in the middle of the Camden case and basically said there's no private right of action. And the Camden case basically got shut down in the process of that. And you heard it tossed out earlier, this idea of 1983, which is a different civil rights law, whether that can be used. And this decision basically shut down that channel too. So essentially, unless you're the government suing themselves, if you're an individual, if you're a nonprofit, if you're a private corporation, you don't have a right to sue over this unless you can prove that discrimination was intentional, which is much, much more difficult to prove. So where this went is that people can now file, or groups can file, Civil Rights Act complaints with EPA's Office of Civil Rights. The track record of that has been beyond miserable. There was a report put out in 2015 by the Center for Public Integrity that looked at this and found that EPA's Office of Civil Rights rejected or dismissed 95% of the environmental justice complaints filed between 1996 and mid-2013 when they did that report. And that same pattern has continued. So I'll give a few examples of how EPA has handled some of these complaints, and then we'll get into more productive avenues. But in 1998, I think this was the first decision made under this Office of Civil Rights. It was a decision called Select Steel. This was over a new steel mill that they were trying to build in Flint, Michigan. And what they held was EPA was taking the position that there could be no civil rights violation because they're going to follow the environmental laws. Well, they haven't even built the plant yet. They don't know if they're going to follow the environmental laws, but they're presuming that, you know, EPA, or in the state, in most cases, a state agency gives out an environmental permit that says stay within certain limits. And they're basically saying, well, as long as you're within those limits, then it can't be a Civil Rights Act violation, which is not true. And the court, the federal court in the South Camden case, agreed that there could be adverse effects from the permitted legal amount of pollution that can still have a discriminatory effect. These are separate legal obligations, but EPA's position has been kind of backwards on that one. In 2011, there was a decision out of California on a case called Angelita C, where they had, they actually won, but even when you win, you lose. They were suing, actually, sorry, they weren't suing because you can't sue. They were filing a complaint with EPA over methyl bromide pesticide spraying near grade schools that are predominantly Latinx communities. And EPA took 12 years to decide it. They secretly negotiated a settlement with the California state agency, didn't involve the plaintiffs, and they settled for additional monitoring and outreach. And ultimately, they ended up switching to a more dangerous pesticide anyway. And EPA is supposed to withhold federal funds, highway funds. That is the penalty for violating the Civil Rights Act. You're supposed to have a big hammer and say, hey, we're going to take away your federal funds if you're going to discriminate. And even though they found discrimination, they have never gone that far. And it seems like they don't have any intention to, but they will settle in secret for crumbs, even when they find there's a civil rights violation. A year later, there was another case out of California in 2012 over the 3 hazardous waste landfills that are all in Latinx communities, low-income ones at that. And they argued discrimination around that. And another shocking, bad decision basically was premised on the idea that the state agency that made the decision, they didn't decide where the facility should go. They just decided yes or no to permit it. That's how almost all of this works. It's very rare that a state agency is the one actually doing the siting. Usually a company says, we want to build it here, apply to a state agency, and the state agency says yes or no. So to let the agencies off the hook on all facilities there that they are saying yes to in communities like Chester, just, it makes no sense. But that was yet another way EPA is dodging responsibility. So there's still groups that are filing Civil Rights Act complaints with EPA. It is good to get a press release if you want to make an issue out of it, and maybe you'll get something good in a settlement. But there's not going to be a private right of action yet, again, unless law is changed. And Senator Tammy Duckworth has a bill, Senate Bill 872, the Environmental Justice for All Act, has 12 sponsors and has been sitting for over a year in a Senate committee, not going anywhere. Not optimistic about that kind of legislation passing, but you know, you're welcome to contact your senators and try to get that moving. there are also controversies around Biden's EPA doing EJ mapping tools that don't even include race as a criteria, which just blew the mind of everyone working on this. We're like, are you serious? But they are so skittish because the Trump administration aide, Steve Miller, is going after all federal agencies that try to use race in any way. And the Biden administration is very skittish about being sued over this, especially with the characterization or the character of the current Supreme Court and where that could land. So that's getting to some positive things while I still have a few minutes on the clock. So actually, I'm going to transition there. So the environmental justice principles don't ask for equity. If you read those 17 principles, nowhere in there does it says spread the damage around better and we're cool with it. Poison people equally. It's not in there at all. It says much more radical things, like basically stop poisoning people, period, redesign our whole industrial economy, how our decisions are made. And I think that's important to understand because almost everything that is called an environmental justice policy is really an equity policy, not a justice policy. And it's a weak effort at that. A lot of times they don't even touch the existing damage on the ground. And for new proposals, they say, well, just do a report or have more public participation or have, in the best cases, like New Jersey passed a law about a year ago that gives the state a discretion to say no to permits in select types of facilities in certain communities. But it's still giving them discretion. It doesn't go as far as saying thou shalt say no if you're trying to build a new big waste facility in a place like Chester. That just doesn't exist. There are not those kind of teeth in any policies we have so far. So what I would recommend is for when we're talking about bad things like waste facilities that communities get polluted by, government agencies need to follow the Civil Rights Act and stop permitting more damage in communities of color, but in any community really. They just don't have the legal power to do that yet. But we need to have policies that apply across the board. If we have a bill passed that says we're banning incinerators, period, everywhere for everyone, guess who's going to benefit most from those policies? Guess who's going to benefit from any policy that says we're going to get rid of a bad activity equally across the board? And then you don't run into these things where these colorblind judges on the Supreme Court are going to say, oh, well, you use race as a criteria, so we're going to strike down that victory, that policy you just passed, which is a serious barrier. Now, for good things, like funding for parks or all kinds of good things that are getting funded, the Biden administration has this Justice 40 concept where they want to make sure that 40% at least of funding for good things ends up in the most impacted communities. Well, people of color are now about 40% of the US population. So that basically is saying we're not going to be racist anymore. But it's not saying we're going to have justice. It's not saying we're going to undo the existing damage on the ground or make up for that disparity by going beyond what equal would be. So I'm basically out of time, but I have a list of actual strategies that we're doing that I know are part of the next panel. I got switched from. So I'd love for folks to ask questions about what we're currently doing and how we can use the frameworks that we do have to make progress, because we're winning a lot and it's a lot to be excited about.
Thank you, Mike. So Sheila, we ask you to bring us home. Thank you much.
Sure. First of all, it's wonderful to be here, and it seems like a lifetime ago that Jerry Bolter and Mike Churchill and Gil and all of us were working together with Zulene in Chester, and it's really sad and devastating that not much has changed in terms of the ability of the people in power, our government, to do right by communities like Chester. There's not much to say because you guys have been so thorough, but I do want to just clean up by kind of talking about the bigger picture here and underline and highlighting some things. I'm going to drop in the chat a piece that I wrote, a very short chapter, which goes through all of my thoughts on the limits of the law in this area, because I don't have time to go through all that. But let me make 3 points, right? And each of these points has to do with the different terrain on which we've been playing or struggling around the limits of the law in this area. And let's start with the Supreme Court, right? 3 things have haunted, I think, the jurisprudence or the court's consistent interpretation of the guarantees of the Equal Protection Clause of the Constitution and our Civil Rights Acts, including Title VI. And those 3 things aren't getting better, they're getting worse, right? And so the first we've already talked about, this requirement that to prove something is racist or racial discrimination, one needs to show what I call specific intent, that the decision maker is out to harm a community by, for instance, giving a permit for more waste, or the kind of thing that happened in Flint when a government official makes the decision that's clearly and foreseeably harmful to a African-American or other BIPOC community. This idea that you have to prove intent has now been written into our laws, both as a matter of constitutional and as a matter of civil rights law. So that's one thing that haunts, right? The second thing is, even when we have a disparate impact standard, as the Title VI regulations do, we now have this second requirement that was reaffirmed in a Supreme Court case in 2015 around Title VIII of the Civil Rights Act, which is the housing discrimination part that has a disparate impact standard. Even when we're talking about disparate impact or intent, courts force you to prove what's called causation, that even if we know something's going to have a disparate impact on a minority community, that the cause of that impact is solely attributable to the decision maker. That's rarely the case because of the interaction of a lot of legacy issues, historical and present discrimination in the market by other actors. So even when these cases find their way into court on the merits, this causation requirement often is, and we saw that in Camden, right? You mentioned the Camden case. When we were litigating the Camden case after the Circler case, and we won at first in the district court judge held that not only was there a private right of action under Title VI, right, but that the environmental agency had 2 legal duties. One was a duty not to discriminate, and the second was a duty to enforce environmental regulations. And then Sandoval came down literally 5 days after that victory and took away the private right of action, and we re-litigated under Section 1983. But the point is that even when those cases get to court as disparate impact cases or under Section 1983, and we then later litigated under Title VIII under the Fair Housing, the causation requirement made those cases very difficult to win. The third thing that haunts, I think, this area at the Supreme Court is color blindness. And we're about to see that the Supreme Court, I think it was Mike that mentioned that the Biden administration has decided, even for its screening, not to use race under the Justice 40, I think, initiative, as well as EJ screening, because of the fear that, as it did with the relief to Black farmers, the courts will invalidate that because it's race conscious. The Supreme Court has an affirmative action case in front of it right now. We are moving more and more towards a requirement that these remedies, even for discrimination, be colorblind. So that's at the Supreme Court. So the litigation in Chester and the Camden litigation that came after Chester have all been caught up in these increasingly narrow interpretations of how we understand race discrimination, racism. And from a long perspective, from someone who's been involved in this movement for 25 years, it's been increasingly frustrating, and it's going to get worse. So then we come to the agency, right? Environmental agencies such as the EPA. And Mike, I was going to go through some of this, but Mike did it, which is great. And that is that after this lawsuit in Chester, the agency created this Title VI guidance where communities could file under the disparate impact regulations at the agency a complaint, right, to invalidate a permit, a complaint of race discrimination, that would be adjudicated just at the agency. We've already been told that the agency took no action on those lawsuits. In fact, there was a or on those complaints, there was a lawsuit in federal court that had to force the agency to act on it. The bigger problem, as I say in the piece that I gave you, is that there has been an unsuccessful attempt, even under the Obama administration, less so under the current one at the EPA, to meld these kind of civil rights concepts of disparate impact onto the way that the environmental regulation regulates the environment. What does that mean? I've said it's like speaking two separate languages that just, they speak past each other. And Mike recounted some of this, but when the EPA is applying a disparate impact Title VI standard to the permits that it has given out under environmental regulations, how much of a particular pollutant can come out of one smokestack, or is this permit, right, does the agent or does the company that is getting this permit meet the current environmental standards? Consistently, what the agency has done is read out of, right, that analysis, the civil rights piece, which is to say, they would say, yes, giving this permit has a disparate impact, but it's not an adverse disparate impact. Why? Because the company meets our environmental standards. So that's basically reading Title VI out of, right, environmental regulation. So the reason that Title VI guidance has been unsuccessful at the EPA is because the agency has a whole different way of thinking about harm than we do under civil rights law. And it's consistently following its very technocratic analysis of harm to the community, which doesn't often consider cumulative or synergistic effects of all the ways in which these communities are exposed beyond the one point source, right? It has a very narrow idea of that, and the civil rights laws or the disparate impact conception tries to expand that, but the agency has read that out. So it's been really frustrating there, notwithstanding new tools such as the vulnerability assessment and the EJ tool. Lastly, I would say, you know, Luke Cole and I wrote about this many years ago in our book From the Ground Up, that, you know, we have to, the last kind of, so I've talked about the Supreme Court and the federal courts, I've talked about the agency, and the last kind of terrain on which we fight this, and that will remain the case, is at the local level, right? Not just zoning laws, but social movements. The law piece has always been, and we've written about this, an organizing tool. We've never thought we were going to consistently win these cases. And the history is that because of the way courts have interpreted these guarantees, we've been consistently losing them. And so the sustainable wins have been because we push local and state governments to do the right thing. So anyway, I'm gonna stop there because we have 4 minutes left and there may be questions.
All right, I just want to say something, because what we all have to understand, as Lewis said earlier, communities that are like Chester and Chester, we have to make lemonade out of lemons. There is no one silver bullet. And although people in the legal realm of things may view Circle versus Seif as a loss, it had the effect of being a win in the community. So I think that what community people, everyday residents, activists, advocates, we can drive the law into the direction that it needs to go. We drive the law with enough pressure, with enough gravity pulling on it and pushing it into the directions that it needs to go, that would offer some relief for communities like Chester. So that's what I want to say.
That's exactly right. And the law is the point is that the law doesn't save us, right? The law is a tool that we use to push for the right result. And our conception of law can't just be about a case. Law is everywhere. And I think it's consistent with what you're saying, Zulene, that there are lots of wins and lots of legal wins. They don't always show up in court opinions, but when we get court opinions like this one, they are incredibly powerful and empowering, right? Even if they're short-lived. And the same thing happened in Camden. Even that.
Another way to say it is the law is only as strong as the movement that it's working with.
Absolutely. That's
Oh, great. That's wonderful, Mike. That's wonderful.
That was Luke Cole and I's whole point. I mean, he had a whole analysis of power relationships and how the law can be disruptive of that. And that's how we use the law in these struggles.
Chris, we had a couple of questions.
I don't see any of the questions being pushed forward to me. I'll ask Nuseba if she has any that.
And we have some with their hands up. Tom Nixon. I don't have we have Tom Nixon in it. Where'd he go with?
Yeah.
So somebody want to unmute him or?
Yeah.
Nuseba, can you unmute Tom Nixon, please?
Sure, one sec.
Well, good afternoon, everybody.
Hello, Mr. Nixon.
Was raised Zulene. I was just in awe of all this information. Living in Chester, and I never knew anything about all this. And
We ass kickers, honey. I keep telling y'all that. We've been on this battlefield a long time.
And I lived in Camden, and I knew very little of the same thing. So it's just really interesting to find all this out that's going on in our little community. And in terms of I think when when they came down to the waterfront, everyone called it trash to steam, and they made it seem like it was going to be a big producer of jobs brought to the city of Chester. So in terms of now looking at 30 years out, what are some things that you think that we can move forward for in terms of fighting Covana and fighting other things that are trying to come into our community? Now we have a new tunnel that wants to be built. I mean, how's all this small little city going to be working with all these polluters, knowing that the health disparities and all these things are there? It seems like the EPA, who has been supposed to protect the community, is fighting against the community and more on the side of corporate America.
And what you're saying is true, but our fight remains the same as Black people in this country. These agencies and entities and things that we know protect other communities, they don't work in and or for our communities. However, we have to hold them to the creed that they are supposed to have. And for example, DEP, we have a constitutional right in Pennsylvania to breathe clean air. That right didn't say it stopped at the zip code for Chester, 19013. But you hold people accountable. You create transparency where you can. You tell your truth and you tell their lies. And you hold them out on what it is that they're supposed to be doing. There is no one magic solution. All of these things work in conjunction with each other. It took the circle a little bit longer to learn that, but we got it now. You don't fight on one playing field. You got to fight on all of them, because all of these things and entities and polluters and the government agencies that are supposed to protect you, they all work in coordination with each other. And many times against communities of color and poor communities like ours. So it's not one thing. You have to learn how to walk and talk and chew gum at the same time on many different fronts. But we are proof. Chester residents, and I know y'all hate that name because everybody bobbles it. I bobble it sometimes. Chester residents concerned for quality living. despite this being our 30th year anniversary, we are absolutely determined that we are worth this fight. We are worth it. And we got skin and blood in the game. And as long as they understand that they will have a force to reckon with if they decide to come up into your community, that's your protection. We are the fucking cavalry. Oh God, I thought I was gonna get through here without cussing. It didn't happen. I tried my best. But we are our cavalry. Ain't nobody gonna ride in and save us. We are it. We are the front line, the back line. We got the 6, the 10, the 3, and the 9. And long as we understand that, long as we understand we will not be prostituted for pollution or profits. No, you're not. You will pay a mighty cost. There have been 7 companies that are no longer in Chester because we stood up and said no. I cannot imagine what would be in Chester had we not come together as a group. They were going to have the largest tire burning company, the largest pet crematory in Chester. They were going to burn soil. They were going to recycle the ash. They were doing medical waste, all on one little patch of land. Kimberly Clark wanted to burn tires. What would have happened had we not, as everyday people, said no? We are worth this fight, and you're not going to do this here. And I really don't think we're something extraordinary. I think we are survivalists. We have learned that we took the lemons and we're making lemonade. And we'll use whatever tool is necessary to get it done. So, but these agencies, they work not on behalf of communities like Chester. We know they work. They work. EPA works in other communities. They do the right thing. But we understand the political climate and the racial climate of this country. So that's where we are. But it can be done. Victory is inevitable. Inevitably, we will shut that incinerator down. Inevitably. Soon. Soon. I don't give a shit if it blows up. Today. Pray don't nobody get hurt. But that's where we are.
I want to ask if any of the other panelists have some closing comments or questions for each other at this point. We have a few minutes left.
Louis, where you at?
I'm right here, Zulene.
He says that like a beaten down husband. I know you're tired. I know you're tired. I appreciate you today for being on here.
Sure, no problem.
All right. I wish all men said that. I'd be all right. You got any closing thoughts, Lou?
I do not. I'm just happy to be able to be a part of this and to see that there is a bigger community stepping forward to and has been there stepping with us to make changes, to fight this battle, to close this incinerator. We really need to do that. We really need to do that. And
Absolutely.
We're going to strive as a goal to do that.
Well, you know, Louis, what the old folks said, as long as you stay on the battlefield,
that's right.
The battle ain't lost.
That battle's not lost. That's
the
right.
battle's not lost.
Mm-hmm.
And we're going to stay on that field. That is what's perplexing to them.
Sure.
With everything that we have going against us, how freaking dare you all stand up to us?
Right.
That's the attitude of local government.
Right.
That's the attitude of the polluters, the regulatory agencies, and their supporters. How dare you? You ought to be happy we killing y'all. Y'all should be dancing in the streets.
That's right.
Well, we're there. And because we are, they're not.
That's right.
There's a whole lot of them that are no longer there. A whole lot of people told us, well, well, it's here now, nothing you could do. Well, they're not there any freaking more.
That's right.
How about that?
That's right.
And that one's coming down too.
Sure.
And we got to march around it 7 times. It's going to come down. Okay.
It'll be 3 years of hell for them.
Hey. It's been hell for them.
Yeah.
Every time we stand. It's well, why y'all marching? What y'all marching for? Oh, okay. Well, building energy.
That's right.
Movement. I got your back.
Great. Well, I want to say that Giovanna, Zulene, and I, when we put this together, we did not have a scripted sense of what was going to happen in this first session, an hour and a half. But I'm just so thrilled that this connection between just looking at this one particular case, but how at multiple dimensions, what's going on viscerally in the kind of resistance that's occurring locally within the community back then and continuing on to the present, but also the national implications of this suit and what it meant for cases moving forward, and also our current situation in terms of how the so-called principle of race neutrality is sneaking its way back in again and making in the most nefarious ways. So this is a real great conversation and dialogue, and I'm quite certain that panels 2 and 3 will have a similar kind of energy and movement in kinds of discussion and conversations and dialogue that we're seeking to have at this conference. So I want to thank all the panelists today for their insights and for sharing their recollections and stories about the case of the time and where we are now as well. So much appreciation for that. For those attending, including the panelists, we reconvene at 2 o'clock, where we're going to be focusing on present efforts and EJ campaigns of the current time. So we hope to join us then. The link, it remains the same. The link that you use to attend this session remains the same for panels 2 and for 3. And with that, any last minute?
1 second, Chris. Nuseva, can you unmute Bigger Dre? Bigger Dre was a young man who was seen in the Laid to Waste video. He was the young man that said, yeah, at the same time you bringing us jobs, but at the same time you killing us. He is now matured into an adult, and a mighty fine adult. Bigger?
I just wanted to.
Okay, there he is.
Can you hear me?
Yes.
I just wanted to say, a lot of times we make ourselves available for things because for monetary gain or just so that we can get a place in the spotlight. And I just want to say that I just want to give high kudos to all those who have the right invested interest in what really matters. So I just want to, that's why I stayed on. I have other things to do. Of course, it's Friday, but I wanted to learn more so that when I engage and I participate, I can be informed and I can share the insight that I've gathered with the community at large. But I wanted to, I probably won't be on it, be able to reconvene back at 2, but I wanted to say you guys did a great job and thank you for the continuous work. I did leave a comment in there, so I'll just say it for those who weren't in the chat. Consistency outweighs resistance. So I appreciate everyone who has been consistent in this fight. And, I look forward to things being resolved. So thank y'all. Thank you for
And do me a favor, you have an event coming up. Please drop it again.
Yeah, so I did share the link. It's our event. I don't like to put the spotlight on me because it's not about the spotlight. It's about.
And I don't like the spotlight on me, believe it or not.
but you are going to be on the panel, and we'd like to have other members of the community to come out. So I did share the link. It's an upcoming event. It's going to be on University of Penn's campus at 4014 Walnut Street from 4 p.m. to 7 p.m. And it's called Chester, A City Laid to Waste Revisited. I think people, when you make an impression on a community, they like to see people who are actually doing the work. So just to see you, like you said, you're coming up on 30 years, still in 22 fighting, I think that makes an impact, and it'll make people recognize like we do have a serious issue. And if we can come together, we probably can have more of an impact, and you can give them updates about, you know, the strides that we've covered. But that's what the event is about. It's at the Rotunda. The admission is free. You can give a donation or a free will offering, but the goal is to connect with the community at large and connect with other individuals and organizations who do similar work. And we're doing it at the Rotunda because, as we know, we're talking a lot about Chester, but this is not a logistical thing. This is happening in areas all around the country. So we're hoping to invite others out, and that link can be shared. The capacity is, because of COVID, it's only up to like 75 people. So if you do share the link, keep that in mind. But we look forward to a large turnout, and we look forward to sharing ideas and seeing what we can do to make things better. And I will see you guys tomorrow, because I will.
All right, future leader.
Yep.
Future leader. Room my long time, but they coming out. All righty. We gonna go get some grits and gravy or something for lunch. Louis, you go get some rest.
I'm at work, sweetheart. I won't be getting rest anytime soon.
Cray. I know. This is what everyday people do, you know. We work, stay up all night like long and go to work again.
Yeah.
That is our life, but we get it done for some way.
Absolutely.
Giovanna, where are you?
Here's Zulene.
Okay.
Thanks to everybody for your commitment, for your words, for joining us, for sharing, and we hope to see you again this afternoon and tomorrow. The struggle keeps moving. One thing I just want to say, because I have students, and we have a student this at the panel this afternoon, Chantal, who is going to law school. So I really think that, and Chantal may say this herself, but she gained, she mentioned this in the chat, gained a lot from hearing from lawyers who have social justice on their minds and in their hearts.
She wants to be one of you. So
yeah,
I hope that you will pick up the mantle and try to mentor this young lady through this process. I knew law school is hard. But we're gonna give her the support we can, because she's one of my children now.
All right, thank you to everybody. Chris, do you have any final words?
No, I think we're good. Thank you. Thanks to everyone again.
All right, let's go get some lunch.